Good afternoon, everyone. I'm Tim Richards, Technical Services Manager of the Managing General Agents Association, and on behalf of the MGAA, I'd like to welcome you to our briefing this afternoon. This is being delivered by Clyde & Co. with Exposures for Directors, the Top Risks in 2024. I'd just like to run through a few housekeeping points. Please ensure your microphone and camera are turned off unless contributing. If you'd like to ask a question, feel free to use the chat button at the bottom of your screen. Time allowing, these will be asked and answered at the end of the event. If we run out of time, questions will be answered post-event. This presentation is accredited for CPD hours if relevant to your ongoing professional development programme. The briefing is being recorded, and a link to the recording will be issued post-event together with the slides and our feedback survey. Please take the time to complete our survey. It will take no longer than a couple of minutes and enables us to continue to deliver the best possible future events to our members. So as a recap, today's briefing is Exposures for Directors, the Top Risks in 2024, delivered by Clyde & Co. Let me introduce you to our presenters, James Cooper and Mark Bezwetherick. James is the chair of the Global Insurance Practice Group and head of the Financial Institutions and D&O team. And Mark specialises in defending civil litigation and regulatory investigations against company directors and officers, professional services firms and financial institutions. So without further ado, let me pass across to James to begin the briefing. So James, over to you.
Okay, thanks for that introduction. So what we're going to be doing today is taking you through how various exposures that D&Os face can culminate in claims that can hit D&O policies. We're also going to try and give some insight into what directors who responded to our annual Global D&O survey told us were concerning them, and drill down onto some of those topics to illustrate what trends we're seeing and how they materialise into claims. So I'll hand straight over to Mark. Mark is going to set the scene by looking at how liabilities can materialise into claims, and then we'll go into the detail of the D&O survey. Thanks, Mark.
Thanks, James. Gareth, if I could have the next slide, please. So up on the screen, you'll see a flowchart we've prepared, which seeks to show in graphical form how D&O risks arise and how they materialise, and ultimately how they hit D&O policies. So we're not proposing to go into detail about every single box, as the chart is hopefully self-explanatory, but this was just to serve as a reminder for everyone that the liability landscape for D&Os is vast and multifaceted. But as you can see from the third row down on the flowchart, the allegations against D&Os can broadly fall into three main buckets, which are regulatory, civil and criminal. And we'll also use this colour categorisation we've used on this chart as we go through the topics and the rest of the slides to show where claims may materialise from in relation to a particular issue. But it's important to note, however, that certain situations a company is in and certain actions by directors may give rise to a number of different exposures. So not every exposure will fall into one of those buckets we've just mentioned. So, for example, breaches of certain statutes may give rise to both criminal and regulatory investigations, and both criminal and civil penalties simultaneously. Likewise, if a company becomes insolvent, the directors may be exposed to both criminal and regulatory actions as well as civil claims. And the consequences in the different categories range from fines, reprimands and censures for regulatory breaches, as you know, damages awards, disqualification and compensation orders for civil breaches, and convictions, which would include jail time for the criminal offences. So with that high-level overview and structure for the rest of the talk, I'm going to pass back to James to introduce the survey.
Thanks, Mark. If we could move on a slide. So with that background, we're now going to look at what directors say are actually keeping them awake at night. So if we can bounce to the next again. So this year, we again partnered with Willis Towers Watson to conduct the Global D&O survey that we've been doing with them for a few years. This was the largest one that we'd had before. We had over 900 responses from 52 countries around the world. And what that's done is given us a really valuable insight into the risks that are of concern to Ds and Os, broken down often by region and also size of company. First of all, we're going to look at the overall top 7 list, and then we'll look at some of the variations by region and company size in particular. So go to the next slide, please. What we see from this, and you'll see 2024 at the far right-hand side of this slide, but we can see here that social risks have climbed the ladder. So health and safety risks are now considered a very or an extremely important concern for 86% of responders. And that's up from an average of 45% over the previous 3 years. And so it now represents the #1 overall concern, up from #5 last year, and knocking cyber attacks off the top spot where we've seen it for the last 3 years. And before that, of course, you can see in 18 and 19, there's still essentially a cyber risk of some kind at the top there. It's unclear really what the precise reason for that rising concern is, but certainly in this jurisdiction last year, we saw some highly publicised fines levied on major corporations like Network Rail and Morrisons, Serco and Transport for London. And then also a noticeable uptick in enforcement notices issued by the Health and Safety Executive and reports of their impressive 94% conviction rate of individuals. But concern about cyber risks does come in at a close second. They continue to evolve, and with the availability of AI tools, the actors are beginning to integrate that into their operations, particularly around reconnaissance and social engineering. And so a recent and latest report by the National Cyber Security Centre shows this beginning of the use of AI. And they say what this is doing is making the attacks much more potent, more challenging to detect, but perhaps most worryingly, potentially lowering the entry barriers for novice criminals. And so we're seeing a marked increase, particularly around global ransomware threat driven by AI. Now, of course, that's a worrying development, not just for directors, but also for corporates. And it adds a further layer of pressure on directors to implement adequate cybersecurity controls and to react efficiently and effectively when an attack happens. And that cyber risk goes hand in hand with the #4 concern, which is data loss. And so the GDPR, having been in force in Europe for a few years now, plus reformed regimes in many other jurisdictions, we're seeing companies and D&Os having some significant fines being issued against them by data protection authorities following a breach. And that law is still continuing to develop in relation to claims from data subjects, not just in the regulatory space, but also in the civil litigation space. And of course, those first-party costs that the company itself is having to swallow to deal with a breach can be very considerable, and the reputational risk around cyber losses can be very high. We then see regulatory actions from financial regulators for cyber systems and control failures being added to the risk landscape. And so a recent example in the UK is the £11.2 million fine imposed on Equifax for cybersecurity breaches in 2017. And that resulted in unauthorized access to millions of American, UK, and also Canadian citizens' personal data. And in fact, this is in line with a trend we've witnessed in recent years for financial regulators to impose significant fines for a range of systems and control failings, demonstrating the importance of those controls, particularly in the financial sector when we're looking at insider trading, money laundering, bribery and fraud, amongst other things. So it isn't a surprise, really, that concerns about systems and controls are a new entry in that top 7 list at #5. And I think we are hoping and continue to advise that boards really take a look at this issue and try and avoid the consequences that can come when regulators feel that they're just not taking systems and controls issues across the whole company seriously. Regulatory risks more generally continue to be of concern, and you see them there at #3, and really with good reason. There's a host of regulators in this jurisdiction and many others who are increasingly exercising their supervision and enforcement powers, and that just continues to contribute to the regulatory space being a difficult one to navigate for directors. The largest activity, of course, emanates from financial regulators, and in the UK, FCA enforcement activity remains a substantial exposure for companies and directors who are regulated by the FCA. And that burden has increased again this year with the introduction of the Consumer Duty, which sets higher expectations for the standard of care that firms provide to consumers. The FCA is also paying close attention to non-financial misconduct, so that's aided by a recent consultation on diversity and inclusion. and it's continuing to promote individual accountability. So directors are expected to lead a healthy culture from the top down, or potentially face consequences from the FCA. And areas of focus in many jurisdictions continue to be tackling anti-money laundering and financial crimes, bribery and corruption, and it's this later risk at number 6 on our overall list. But we see it climb to number 1 for the largest companies, those with turnovers of in excess of $5 billion. And that reflects the increased focus by prosecutors on this area and the international coordination that we see in these types of investigations. From a personal responsibility perspective, last year also saw the SFO in this jurisdiction securing its first deferred prosecution agreement related conviction, and that followed a company called Blue entering into a DPA related to bribes in relation to securing office refurbishment contracts. Although the following week, of course, they then dropped 3 other cases against individuals related to G4S. So they take with one hand and give 3 back with the other. I think overall that sort of list of top 10 7 risks reveals the various difficulties and challenges that directors encounter, which can have serious implications for them. And we've summarised how claims might materialise on this next slide. If we can move on, please, Gary. Now, to avoid and reduce those risks, it is, of course, essential to have effective risk management and appropriate systems and controls. Of course, that's particularly difficult when you're underwriting these types of risks to really get a feel for the culture and understanding as to how effective those systems are. We drill down a little bit more, so moving on to the next slide and looking at by company size. So we saw that the overall picture on a couple of slides back, but we do see differences when looking at the largest to the smallest companies. So we see here, again on the far right-hand side, that for the largest companies, as I said earlier, health and safety drops to number 2, regulatory concerns rise to number 1, and bribery and corruption pulls its way all the way up to number 4. When you look at companies with revenues over $1 billion, they're also the only companies that are concerned about breaches of sanctions law. But conversely, when you look at insolvency risks, they're only of concern to the smallest companies. And whilst it is, of course, true that SMEs are quicker to fail, large companies are certainly not impervious to the risk of failing and the consequences that can follow for directors. And I suppose worryingly, according to the UK's January 2024 statistics released by the Insolvency Service, the number of registered company insolvencies was 1,769, which was 5% higher than in the same month in the previous year and higher than levels seen prior to the pandemic. That trend is also reflected in most international jurisdictions that we're aware of. We have noticed in the last few surveys that there is a bit of a disconnect between the perceived risk and the actual risk to individuals, especially as insolvency related claims are a large source of claims against directors in many jurisdictions, including the UK. We'll talk about insolvency in a little bit more detail in a moment. Looking at some of the changes by region, if we can move on to the next slide, Gareth. It has to be borne in mind that the responses aren't evenly spread. Most responses are from the UK and Europe. But that having been said, the following points I think we can note. Health and safety is a concern in all jurisdictions. It tops the list for all except for the UK, where it comes second to data loss. And in fact, data loss is the only other risk to feature in the top 7 for all regions. Cyber risk also features high for all regions, with the exception of Africa, where it just doesn't feature at all. And then, interestingly, climate change is only perceived as a significant top 7 risk in 3 regions, being Australia, Asia, and Middle East, but it is just slightly outside the top 7 in the other regions. So again, we'll talk about ESG in a moment, but it's interesting to see that the E part of ESG is really not seen as a particularly high risk for Ds and Os, notwithstanding all of the chat in the media in particular. Moving on just very briefly to changes by industry. Thanks, Gareth. When we look at it by industry, there are, of course, some differences. So, for example, cyber attacks and systems and controls feature at the top for finance and insurance, and data loss is number one for services. Health and safety tops the list for other industries, but climate change only features as a concern for the energy and utility industry. Again, perhaps not unsurprising. So we're now going to drill down a little bit more into some of the risks that we've just talked about, and also look at some other key liability trends. So if we can move on again, Gareth. The first we'll look at is ESG. Now, the primary focus in recent years has been on E, the environmental risks, particularly climate-related risks. But as we know, ESG is far more wide-ranging and encompasses a range of issues under the S, or social umbrella, so things like workplace culture, DEI, community impact, and then the G, the governance umbrella, which ensures that the board of directors is identifying, analysing, putting into action and reporting on the E and S issues. On this slide, there's just a non-exhaustive list of the factors to illustrate this. We can move on to the next slide. The survey results show that all ESG related risks are of more concern to directors than they have been in the past, but social risks like health and safety, human rights, supplier business practices, employment claims, those types of things, they've all particularly grown in importance, with each risk perceived as much higher than in previous years. And there's many reasons why these S issues have become increasingly important in recent years. That includes things like changing consumer attitudes. So consumers express a lot more interest and concern nowadays about how companies' operations impact on society. There's more attention on social issues as a result of highly publicised cases around inequality in human rights. There's a regulatory pressure to improve corporate behaviour, make boards more accountable, that type of thing. And then there is an increasing demand from investors who want to know how social factors are being incorporated into investment decisions. And there's also a much greater awareness of studies which have indicated that a company which invests in good, responsible social practices results in better financial performance. One of perhaps the most notable developments in the last year relating to ESG is the increase in the anti-ESG sentiment, which is probably most evident in the US. Other jurisdictions haven't witnessed a similar backlash as of yet, or at least not to the same degree. But I think even in this jurisdiction, green issues have at least been deprioritised of late in some quarters. Now, that of course makes it even more difficult, doubly difficult for directors to navigate this, because not only is there a need to understand the politics around ESG, but on top of that, there is an increasingly complex patchwork of current and upcoming rules and regulations which are applicable to ESG. That ever-changing landscape just makes it so difficult to navigate. That political overlay adding volatility and unpredictability as to the direction and speed of travel. And that's particularly so for directors of multinationals. So it's hard enough to understand what's going on in this jurisdiction, but when you overlay that with the US and a couple of European jurisdictions, that type of thing, trying to understand those upcoming regulations and overlaying it with the political landscape just makes this so very, very difficult. That regulatory space is definitely driving the risk for directors, though. We've seen significant corporate governance reforms in recent years in the UK. Those are looking to increase the accountability of companies and directors. There's also additional reporting obligations in many jurisdictions. So, for example, in the UK, there's now specific climate-related disclosure rules. They're a mix of mandatory and comply and explain, depending on the size of the company and whether it's listed. There's also a consultation going on, as I think I touched on earlier, around DEI issues. In the EU, there's the Corporate Sustainability Reporting Directive, and that's looking to expand the scope of the companies which are required to make sustainability disclosures, and includes more stringent and harmonised reporting obligations. And then in the US, there's been the recent announcement of SEC disclosure rules as well. But it isn't just the non-financial, it's not just the financial disclosure. there is also greater scrutiny now around non-financial disclosures. So a raft of new regulations which can result in regulatory action if breached. So again, in this jurisdiction, the FCA has announced a new regime, it's PS 2326, to increase trust in the market when it comes to disclosure and labelling of sustainability issues for financial products. So there's now a new anti-greenwashing rule that comes into force at the tail end of this month. It makes UK-based firms, they have to now ensure that sustainability claims are accurate, clear and fair. There's only 4 new labels that can be used for investment products which are sustainable or ESG compliant. There's now also rules on proper marketing and information about the sustainability of financial products and services to protect consumers and improved investor confidence. In the EU, MEPs have recently announced that they've adopted a directive also to protect consumers from deceptive marketing practices. So again, going back to what I said earlier, it's this increasing complexity in and around the regulation of ESG issues. Move to the next slide, please, Gareth. Again, what we're trying to do here is just summarise at a high level where ESG issues can lead to claims. Again, it's a non-exhaustive list, but it gives you a flavour of how far-reaching ESG issues are. Regulatory investigations, enforcement proceedings are bad enough, and we're seeing those already occurring in the US and Australia. But of course, what quite often follows a regulatory investigation or action is some form of securities class action or shareholder derivative suit, which you see there in the sort of red magenta box at the far right, the civil box. So we saw last year shareholders increasingly looking to use derivative action process in this jurisdiction to try to hold directors accountable for climate-related risks. And so we saw a couple of interesting cases, Client Earth against Shell. There, the claimants were arguing that the directors should be personally liable for failing to implement an energy transition strategy that's aligned with the 2015 Paris Agreement. And in the same year, we also saw a case called Ewan McGahey and the University Superannuation Trust. And there, the claimants alleged mismanagement of the fund on several grounds, including overinvestment in fossil fuel assets. Both of those cases failed at the first stage, the permission stage, but it shows you the direction of travel around how a lot of these NGOs, the non-profit sector, is looking to use commercial litigation to try to change behaviours. So it's not just the sort of plaintiff bar that we see in the US trying to drive damages. These are non-profit organisations who are using litigation to try to effect change. So we don't expect that to calm down. And I think what we're going to see over the course of the next few years is the courts beginning to examine properly a director's duty in an ESG context. There could also be criminal exposures. I don't think we're necessarily seeing that as a particularly high risk, but if a director consents or connives in the commission of an offence under environmental or health and safety laws, that already exists. So under the S, we can see some criminal exposures, probably less likely around the E, the climate change issues at this stage. But hopefully this has at least given you an indication of sort of how enormous and how fast moving this area can be, and how it's extremely challenging for directors to try to find a course through, particularly with that current political sentiment. So I'm going to hand over to Mark now. He'll take us through some of the insolvency issues.
Thanks, James. Yeah, just to drill into the insolvency a little bit more, if we could move to the next slide. Thank you. As James mentioned earlier, the insolvency-related claims are a large source of claims against directors in the UK, though, as he noted, only the smallest companies actually considered insolvency-related risks as a top 10 concern in this year's survey. But the risk of claims has increased as insolvencies have rocketed in recent times, following all-time lows during 2020 and the first half of 2021 during lockdown. And further, during difficult economic times, there's a higher risk of fraudulent, dishonest and wrongful actions, and all of this can lead to more actions by insolvency practitioners against D&Os for breaches of insolvency legislation, as well as their duties to the company, but also to disqualification proceedings as well. And so according to the statistics for the Q4 of 2023 released by the Insolvency Service, which are on the screen there, the number of registered company insolvencies for 2023 was 25,158, which is the highest annual number since 1993. And some recent reports also claim that around 44,000 UK companies are on the brink of collapse. The Insolvency Service has always actively pursued disqualification proceedings. However, these actions have certainly increased in recent years, in part due to new powers given to the Insolvency Service to investigate directors under legislation, including the Rating Coronavirus and Directors Disqualification Dissolved Companies Act, passed in 2021. Now, that act aims to prevent companies from evading their debts by dissolving and reforming under a new name, but with the same purpose and assets. And effectively, this is what the Insolvency Service would consider to be Phoenix companies, which arise from the ashes of the old companies to start afresh. And in particular, the government was keen when drafting that legislation to ensure that the act of dissolving the company does not allow those companies to avoid repaying government loans given during the pandemic, such as the Bounce Back Loan Scheme. And there is also evidence in the statistics that the Insolvency Service is aggressively pursuing directors who did abuse COVID-19 financial support schemes. Of the 850 director disqualifications, 583 included an allegation relating to COVID-19 financial support scheme abuse. And also that the Insolvency Service are pushing for longer periods of disqualification that we've seen in previous years. The average length is now 8 years, 4 months, which is up from 5 years, 10 months in 2001 to 2022. The Insolvency Service has also brought criminal prosecutions against 6 directors in 2022-2023 for COVID-19 related misconduct, and all of those prosecutions resulted in a conviction, and 3 resulted in immediate imprisonment of the directors as well. Finally, the Insolvency Service can also bring compensation orders against directors. Compensation orders aim to make those directors financially accountable for the consequences of their unfit conduct. And on the 1st of September 2023, the first court compensation order was granted, with a Mr. Gimpu who being disqualified for 13 years and being ordered to repay £50,000 to the public treasury following his exploitation of the Bounce Back Loan Scheme during the pandemic. And we expect to see more of those types of actions in this year and in the years ahead. As James mentioned, there's also potential for sector regulatory actions. For example, the FCA will often use its regulatory powers, including enforcement actions after insolvency, for misconduct by firms or the senior managers where appropriate. And just moving on then to the next slide, to where we've just summarised again the types of actions. Again, this isn't an exhaustive list, but again, we see just an illustration of how insolvency claims arise in both the regulatory, criminal and civil space. And Gareth, if we could just move on to the next slide as well, then we'll just drill a little bit more into some of the cyber side of D&O exposures. As James mentioned, cyber-related risks remains a top concern for D&Os. Ever since 2018, it has featured in the number 1 or 2 spot in the survey, and it's interesting to note that year on year, the concern has been steadily increasing. This reflects the ever-changing risk, which it is hard for D&Os to keep on top of, but also combined with the increasingly aggressive regulatory environment, which has led to more proactive enforcement, higher fines and regulatory costs. James mentioned earlier how those risks have evolved in recent times and the impact of AI on that risk level. But however, just in this next section, we're going to focus more on the regulatory outcomes. So currently, UK GDPR applies, but a new piece of legislation, the Data Protection and Digital Information Bill, which was introduced to Parliament last year and is currently going through the parliamentary process, is now at the House of Lords' 3rd reading stage. Whilst the substance of that GDPR legislation is not likely to be weakened, it is intended to reduce administrative burdens and will aim to introduce a bespoke British data protection system. So in addition, the government is also seeking to update the Network and Information Systems regulations, which were originally derived from the EU's NIS directive. Changes will aim to boost security standards and increase reporting of serious cyber incidents by bringing managed service providers into the scope of the regulations and improving incident reporting. And those updates will be made as soon as parliamentary time allows, assuming we don't get an election before then. And with those proposed changes in legislation, we question the extent to which departing from GDPR may in fact lighten any existing burdens. There are many, and in fact, perhaps most organisations in the UK which process personal data in the EU or of the EU individuals. And in these circumstances will be required to comply with both the EU GDPR and any new UK legislation and regulations. and any divergence between the two is likely to increase, therefore, rather than decrease their data protection obligations. And just moving on to the next slide then, just a summary of how those claims may materialize. In terms of enforcement trends, there's a general recognition that material fines are not the only way to sanction controllers and ensure GDPR compliance as part of the Information Commissioner's Office new approach for the UK. In a number of recent speeches, the Information Commissioner, John Edwards, who's been in his role for just over a couple of years now, declared a step change in the ICO's enforcement approach. Fines will remain an important regulatory tool, and the ICO will use them in instances where they're truly needed for the breaches which cause or have the potential to cause the harm to most people, or where a business has profited from its non-compliance. But instead, we're also now seeing a shift towards publishing reprimands. The ICO will publish all reprimands going forward, including reprimands issued from January 2022 onwards, unless there is a good reason not to. And why is it doing that? Well, a number of different reasons. Firstly, it's about accountability. It's also about the rest of the economy needing to know what's happened, the reason for the infringement and what the ICO did about it, and finally, to give organisations certainty and clarity as to what the law requires from them. Cyber events could also lead to enforcement action by financial regulators for systems and controls failings. The recent example of Equifax, which James has already mentioned, relates to cyber breaches that occurred in 2017, an action brought by the FCA following unauthorized access to millions of personal data of citizens from the US, UK, and Canada. In terms of third-party liability risk, whilst there's growing third-party risk in some jurisdictions, the UK data litigation market largely ground to a halt in light of the decisions in Lloyd and Google and Warren and DSG, which has to date severely undermined the viability of mass litigation and smaller data breach claims respectively. In particular, the courts are giving short shrift to claims for distress where there was a breach but no real distress or financial loss has been caused. While some smaller cases progressed to trial and several have been referred to county courts, High Court judges have dealt with only a handful of cases since Lloyd and Warren, and all other opt-out cases have been withdrawn. And cybersecurity breach follow-on claims have struggled to get off the ground. Whatever the risk of regulatory action and third-party litigation, a major cyber incident can still be an existential threat for any business, and it's relatively easy to see how the D&Os, any failure to take reasonable steps to prevent attacks, or to, for example, to ensure adequately against the consequences of a breach, can be used to frame a claim against the directors for breach of their duties. So just to give you an example, we're dealing with a case at the moment, and which shows how simple it can be to frame a claim based on cyber risk. It's a claim against a established SME entity whose CEO and director signed off on a $5 million transfer of funds that, unfortunately for him, was actually part of a social engineering fraud and was irretrievably sent to the wrong counterparty as part of a concerted and quite clever fraud. In terms of the CEO, his employer then decided to dismiss him, brought a civil action against him for breach of his director's duties to act with reasonable skill and care in approving that transfer, and then notified its own claim under the company's D&O policy for an indemnity in respect of the former CEO's anticipated liability to the company. So in that context, fairly easy to frame that claim for breach of his reasonable duty and something he unwittingly got involved in. So just an example of a current case that we're dealing with. And on that, I'll pass back to James, who's going to drill into a little bit more detail on the regulatory side of things.
Thanks, Mark. If we could bounce on another slide then. So I'll talk about regulatory risk now. It remains a top concern for directors, and since 2018, it's been at either number 3 or number 4 on that top 7 risk list. Scrutiny forms the basis of many risks that directors face, particularly in this jurisdiction, as well as many others in the developed world. We've already noted in relation to ESG and cyber, for example, firms in the financial sector face a very heavy regulatory burden, and that's amplified, as I said earlier, by the introduction of the new consumer duty. And so we're going to focus a bit more, I think, around financial services. So enforcement action by the FCA remains a substantial exposure for companies and directors in the UK when they are regulated by that entity. And what we saw in the 22-23 annual report and accompanying enforcement data was that as of the 1st of April 2023, there were 591 open enforcement cases relating to 224 investigations. And whilst the number of new cases is lower than in previous years, there has been an increase in the use of early intervention measures and the imposition of non-financial sanctions with the aim of catching breaches and wrongdoing at an early stage. And we've seen a real steady increase in the FCA's willingness to use their criminal power. And the data shows that 300 of the 591 open cases in April last year involved a criminal action of some kind and were being pursued under the dual track process. The vast majority related to unauthorised business. That continues to be a target area for the FCA. And the FCA instituted criminal proceedings against 13 individuals for a range of criminal offences. Those included market manipulation, breaches of general prohibition and money laundering. And as of the 1st of April 2023, 20 individuals were facing prosecution in the criminal courts. And the FCA's made it clear that it's going to continue to utilise its criminal powers alongside the broader aims to tackle financial crime. That's increasingly being monitored by the opening of financial crime supervision cases. FCA also imposed more fines last year, 24 up from 12, with a total value of £199.3 million. That was down from 313 million in 2021. The largest single penalty was 107.7 million imposed on Santander for failures in relation to anti-money laundering controls. There were some other very large penalties. There was TSB at 29.7 for its IT failures, Citigroup Global Markets for 12.55 million for failing to meet trade surveillance requirements under market abuse regulation. And a theme that runs through that large fines are failures in systems and controls, which we've already discussed a little while ago. The average duration of investigations, I suppose worryingly, has moved up from 42 months in 2021-22 to now 65 months. So quite a long period of time now to be dealing with an intensive investigation. What those the position vis-a-vis individuals? The FCA's handbook states in relation to individuals its attitude to bringing claims against individuals rather than companies. And it says it recognises that cases against individuals are very different in their nature from cases against corporate entities. And the FCA is mindful that an individual will generally face greater risks from enforcement action in terms of financial implications, reputation and livelihood than would a corporate entity. As such, cases against individuals tend to be more strongly contested and at many practical levels are harder to prove. They also take longer to resolve. However, taking action against individuals sends an important message about the FCA's statutory objectives and priorities, and the FCA considers that such cases have important deterrent values. The FCA is therefore committed to pursuing appropriate cases robustly and will dedicate sufficient resources to them to achieve effective outcomes. So we see that individuals are frequently enforced against by the FCA, and senior managers and directors are also often criticised in enforcement findings against firms. There's also actions against directors and senior managers under the senior managers and certification regime, which was brought in 2016. But actually, the number of those has been quite low. And as at the end of 2023, there had only been successfully brought 2 actions, a third is being challenged. And the number of investigations has been low. It's not clear why, because the regime, when it was brought in, was designed perhaps to make it slightly easier, not just to become regulated and to go through that approval process, but also to allow the FCA to more heavily regulate individuals. There is, though, a growing area of concern that needs to be on directors' radars, and that's non-financial misconduct. So the FCA has proved itself willing to ban individuals for lacking necessary integrity and reputation, which is a core aspect of the fit and proper assessment. It's historically been challenging for firms to know which conduct breaches FCA conduct rules or whether the person in question could still be considered fit and proper. And that's made it hard to determine when notifications to the regulator should be made. There was an attempt to address this in September last year when the FCA launched a consultation setting out proposals for a new regulatory framework for diversity and inclusion in the financial sector. That included clarifying and strengthening expectations around non-financial misconduct and achieving a healthier firm culture. Amongst other things, it's looking to better integrate non-financial misconduct considerations into staff fitness and proprietary assessments, conduct rules, and the suitability criteria for firms to operate in the financial sector. The PRA has also launched a consultation on the same subject. Both of those consultation papers closed to comments in the middle of December last year, and policy statements are expected later this year with new rules in 2025. And this is all set against, of course, those broader aims to improve conduct and firm culture. That's a long-standing priority for the regulator, and we could see actions against directors for their own misconduct, but also for turning a blind eye. And a case in 2023 clarified that that type of conduct could found an action for lack of integrity. I'm going to hand over to Mark again. He's going to talk about sanctions.
Thanks, James. Just move on to the next slide, please, Gareth. Just to drill into the sanctions risks for D&Os a little bit more then. Interestingly, concern about sanctions entered into the list of top 7 risks that James mentioned in the survey this year for the first time. Since the start of the war in Ukraine, the sanctions regime has ramped up, and we've seen the introduction of tougher sanctions alongside new legislation, including the Economic Crime, Transparency and Enforcement Act 2022, which came into force in March 2022. And this is designed to make it easier and quicker to impose sanctions and to identify and trace illicit wealth. In terms of the risks for D&Os, civil monetary penalties may now be imposed by the Office of Financial Sanctions Implementation, where it is satisfied on the balance of probabilities that the person has breached sanctions regulations. It no longer needs to show that the individual knew or had reasonable cause to suspect that their conduct breached the financial sanction, or that they'd failed to comply with any obligations imposed on them by sanctions regulations. Further, there's also the spectre of reputational damage, as the OFSI may now publicly report a breach, whereas previously reports were only made where a monetary penalty had been imposed. And whilst to date there's not been a stream of enforcement actions so far, exposure to enforcement actions may increase further as a result of the government's announcement in December 2023 of a new unit, the OTSI, or the Office of Trade Sanctions Implementation, whose role is to clamp down on Russian sanctions evasion. The OTSI is intending to play a pivotal role in assisting businesses in complying with the sanctions, but also investigating potential breaches, issuing civil penalties, and where necessary, referring cases to HMRC for criminal enforcement. And the OTSI is expected to launch fairly soon. So much changing on the sanctions front. If we just move on to the next slide then, to drill a little bit more into corporate criminal liability as the final topic. Bribery and corruption concerns have featured on the top 7 lists for the last 3 years, which likely reflects, as James noticed, the increase in international cooperation in relation to these crimes. These crimes can be prosecuted directly or on a failure to prevent basis. And this model places the onus on the company to put in place reasonable or adequate procedures to prevent the crime in question. Now, the corporate criminal liability landscape was expanded significantly in 2023 with the enactment of the new Economic Crime and Corporate Transparency Act 2023, or ECTA. It introduced a new corporate offence, as many of you will know, a failure to prevent fraud, holding organisations liable if their employees commit a fraudulent act for the organisation's benefit. Now, this offence applies to large organisations, which is defined in, at least as any organisation which meets at least 2 of the following criteria: having £36 million or more in turnover, more than 80 million in terms of its balance sheet, and or 250 employees. And the organisations can defend themselves against these charges by proving that they had reasonable procedures in place to prevent fraud, or by proving that it was reasonable not to have those procedures in place. Now, ECTA has also reformed the identification principle, which was a common law test that previously only allowed liability to attach to an organisation if the offence was committed by an individual representing the directing mind and will of that organisation. Now, under Section 196 of ECTA, an organisation will be criminally liable where a senior manager has committed the offence. And a senior manager is defined as an individual who plays a significant role in the decision-making or management of the organisation's activities. And this evidently widens the pool of people who can be caught by the identification principle, increasing the number of individuals who can attribute criminal liability to that organisation and may therefore lead to more prosecutions. So for now, these provisions only apply to the economic crimes listed in Schedule 12 of ECTA, which includes the offences of bribery, fraud and false accounting. However, further changes that can be expected on the horizon as a result of reforms tabled by the Criminal Justice Bill, which is currently at the report stage before the House of Commons, are likely to extend the identification principle yet further, as it makes provision for corporate liability where a senior manager commits an offence whilst acting in the scope of their apparent or actual authority for any crime. And so therefore, as to its impact on D&Os, the expectation is that corporate cases will result in DPAs, deferred prosecution agreements, entered into between organisations, but not the directors and the prosecuting authorities. The DPAs themselves are agreements whereby the sanctioned entity's prosecution is deferred in exchange for payment of a fine on the condition that certain agreed conditions are met. And this process typically requires significant cooperation on behalf of the corporate entity, which can include implicating wrongdoing by individuals who may then be more likely to be subject to subsequent prosecutions. And finally, one might also expect them to be more civil claims and criminal prosecutions to be pursued against senior management or the associated persons involved as well. So a lot changing on that front as well. I'll just pass back now to James to discuss class actions.
Thanks, Mark. If we can bounce on one more. So class actions, then they're not actually a top 7 risk, but they are a huge risk for companies and D&Os in a number of jurisdictions, and increasingly so in this jurisdiction. So we did want to spend a little bit of time just taking a look at them in the UK in particular. It's also, I suppose, worth pointing out that these are risks for directors, even if they aren't named in a collective action. So often in the US, they are named, but not always. And there's examples in the UK where they are named and unnamed as well. But even when not named, they're going to be required to give significant evidence at trial, often over many days. And that can impact upon their reputation and cause reputational damage. They can also be follow-on regulatory and criminal actions if the conduct is found to be so egregious in that underlying piece of civil litigation. But looking just very briefly at securities actions in the UK, they can be brought under common law or statutory provisions under FISMA, and we set out there on this slide section 90 and 90A of FISMA. Section 90, directors can be potential defendants to a section 90. The defendants are the persons responsible for the prospectus. That includes the issuer, but also each director of the issuer. Section 90, which is all to do with market disclosures and non-disclosures and purchases on the secondary market, so much more akin to the American Section 10B. In this situation, it is the knowledge and the actions of an individual, a person discharging managerial responsibilities, which impacts upon the liability of the company. But an individual cannot be a defendant in a Section 90A claim. There could, though, be back-to-back liability for the issuing company under Section 463 of the Companies Act, or otherwise for breach of fiduciary duty or negligence. Now, interestingly, these provisions have been on the statute books for 2 decades, but we have had almost no judicial consideration, just a small consideration a couple of years ago in relation to a post-M&A context, which was the autonomy and lynch claim. So there is real uncertainty as to how these claims will be decided, and there's certainly no playbook to follow for settlements. And there have been a number of settlements of Section 90 and 90A claims over the course of the last couple of years, and they do settle for very different percentages than the American versions of these claims. Now, we're hoping that 2024 is going to bring the first judgment. That's the Serco claim, which starts any day now, unless it settles. Now, many of the current claims are, of course, against the largest companies in the country, like a Serco, a G4S, etc. Some of the others that are in the public domain. But there are others which are brought against significantly smaller entities and their directors. And so one that we're defending at the moment relates to the raising of just over £100 million in an IPO by a medium-sized energy company, which collapsed following that IPO. If we can move to the next slide. There has been an issue at the moment as to the basis or the procedure for bringing these claims. And so we obviously have the opt-in basis under a group litigation order. There has been a rising attempt to try to use the representative mechanism for securities claims, and that allows an opt-out type action to be brought, and that's much more akin to the American process of opt-out class actions. So it's brought on behalf of a class, and unless you opt out of that class, then you will be a member of that class. And that results in very significant class sizes and potentially significant damages exposures. Now, there's a lot of wrangling at the moment as to the requirement under the Civil Procedure Rule 19, which regulates representative actions. There has to be the same interest involved for all members of the class. And so there has been some wrangling in recent years as to how that is to be applied. And whether, in fact, therefore, you can use a representative action for these types of securities class actions. There was a case towards the tail end of last year called Wirral and Indivia, where the door, certainly in relation to that case, was closed. It was, however, all to do with the court's discretion, the way in which the claimant was trying to essentially bifurcate the amount of work they would have to do to bring the claim versus the amount of work the defendants would have to do in the first part of the action versus the second part of the action. The court felt overrode their discretion to case manage as they saw fit. So that case, the representative action process was closed on. Doesn't necessarily mean that the claimant bar isn't going to find a way to do it. And of course, as you would expect, that case is also being appealed. You probably heard a little bit, if we move to the next slide, sorry, around competition claims. And this is another potential area of exposure for directors, which is these large opt-out claims for competition breaches under the Consumer Rights Act of 2015. And once a class representative has filed a claim under this act, the Competition Appeal Tribunal considers whether the claim is suitable to be dealt with on a collective basis. Quite a few cases running through there at the moment. There's a big Forex claim, for instance. There's also the MasterCard claim, which has a £10 billion potential damages attached to it. So very large pieces of litigation. At this stage, directors, as we understand it, have not been named in these proceedings. But of course, there could be plenty of follow-on actions or derivative actions that we see in jurisdictions such as Israel. So the development of the competition claims really should be borne in mind when considering risks directors in this jurisdiction. Next, and I think final slide, please. Litigation funding, though, in order to bring these large class actions, litigation funding is absolutely crucial. It's been crucial to the rise in these actions in the UK and in many other jurisdictions, in particular Australia. And it was thought for a long time that the litigation market had been dampened by a case known as Packer, which came out over the course of the summer holidays last year. And that seemed to bring to an end the ability to use litigation funding because it was potentially in breach of some regulations around how you're allowed to conduct litigation in this country. Quite a lot of uproar, particularly following the Channel 4 docudrama about the sub-postmasters. And so there was a good few months where there was quite a lot of wrangling and wringing of hands. And then earlier this year, a couple of months ago, the government has come out very strongly and it's issued a bill called the Litigation Funding Agreements Enforceability Bill. Very, very broad brush, very, very simple language, and reverses the position to put litigation funding back on an even keel. It is retrospective, which is causing quite a lot of controversy because we don't normally do retrospective primary legislation in this jurisdiction. So whether or not the retrospective nature of this slows things up, we don't know. It's already gone through committee at the House of Lords. It goes to the report stage at the House of Lords at the beginning of June. If it continues this pace, it should pass the Commons sometime this year. So that would put litigation funding back in, and that would then start the drive that we had seen towards this mass redress. Now, what has also happened, however, is that the Civil Justice Council has announced that it has been asked to review litigation funding in this jurisdiction, and in particular to consider regulation of litigation funding and things like caps on maximum recovery that can be made. Now, that means there's going to be a lot of lobbying going on, an awful lot of debate going on around litigation funding. But I think a regulated litigation funding process and market in this jurisdiction means that litigation funding becomes slightly more acceptable to be used, perhaps. And therefore, we don't anticipate that any kind of regulation or caps is going to necessarily slow down the growth in these securities class actions that we're seeing, and therefore really start to play around a little bit with the amount of exposure that directors, and in particular side B and C D&O policies could start to face in this jurisdiction over the course of the next couple of years. So we hope that you found that useful. Obviously, there's an awful lot in the survey that we've done. Happy to take any questions now. I'm not seeing any in the chat box, so we may well have beaten it out of you. But if you have got any questions either now or later, our contact details are on, I think, the next slide. And also the slides, I think, will be circulated, so you can always get in touch with us in that way. But I'll stop talking for 30 seconds just to see whether any questions do appear in the chat box.
So if you do have any questions, anyone, feel free to put them in the chat box, as James says, or indeed come off mute. Or we do have a question that's just come in. Do you have any views on the FCA's proposals around early publication on enforcement cases?
I suppose only personal views, really. I think the uproar around it has been so extreme that it's likely to be watered down. But I think it's a drive towards more transparency. It's a drive towards perhaps a greater profile from the FCA in the work that it does. So I can see why there is a concern that it makes us slightly less competitive when it comes to looking for companies or financial services companies to set up in this jurisdiction. But on the basis that, when the Americans, they do the walk of shame, for instance, and when they arrest people, they put them in orange jumpsuits, in handcuffs, and walk them up the court steps. That hasn't stopped America's growth around financial services. So I'm not entirely sure that early publication of enforcement cases is likely to lead us to be seen as anti-competitive versus some of the other capital requirement rules, for instance, that exist in this jurisdiction. So it'll be interesting to see whether those proposals make it all the way through, but I wouldn't necessarily see it as an entirely bad idea.
Thanks, James. And on that note, we're just about at time, so I think we'll wrap up there. So just remains for me to say thanks so much to James and Mark for a very interesting and useful session. You can reach both presenters, as mentioned, at the contact details shown, or feel free to contact me at tim.richards@mgaa.co.uk with any questions or introductions, and I'll be happy to pass these on. Thanks everyone for joining us. Please don't forget to provide your feedback, and do look out for forthcoming MGAA events. I do hope you all have a great afternoon. Thanks again for joining us, and see you all soon.